recording is offered as a general source of information only. Contents are not intended as a solicitation to buy or sell specific investments or to provide tax, legal, or investment advice. Always seek advice on your specific circumstances from your financial advisor. Views of guest speakers may not be shared by Cory Vance or Arctic Fox Financial, Inc. Welcome, everybody. This is Open Office Hours with Cory Vance, financial consultant. I do financial plans for clients and I give financial advice. The biggest thing that I do, or how I do that, is that I help small business owners protect and grow their business and portfolio wealth as really two halves of one holistic financial picture. Obviously, your business is important to you and your personal portfolio is important to you. Most business owners have most of their financial assets tied up in their business. So in helping you protect and grow the wealth and the assets in your business, that allows you to, if we focus on each part of that holistic financial picture, and we can leverage both of them together and help your whole financial asset picture grow faster and safer. So that's what I do. Open office hours is just an opportunity for you to get to know someone in the financial services field in a low pressure, no pressure way. Get some of your questions answered and just sort of peek behind the curtain, as it were, as to someone who gives financial advice and does financial plans. So that's a bit about me and what I do and who I am. There's more places you can find out more about me, LinkedIn, on my website, etc. I'll give some contact information is down here. I always got to remember which way to point. You can click on this QR code here and schedule a no charge appointment just to get to know me and see if we're a good fit to work together. But the real reason we're here tonight is I want to introduce my special guest, and that's another reason why I think you're here, to see what assets are out there in terms of what kind of professionals are available to help you protect and grow your wealth. I'm pleased to welcome Angela Yee-Hamshaw here tonight as my special guest. Angela is a wills and estates lawyer practicing here in Calgary. She's in her 25th year of helping Canadians prepare their final wishes. She's worked in the banking industry, she's worked for the Alberta government, and she's also worked in private practice. So she has a wealth of experience that helps her give a broad perspective when serving clients. She's highly regarded in the Calgary legal community, and I'm proud to have her here tonight. Welcome to Open Office Hours, Angela.
Thanks, Cory. I'm happy to join you tonight, and thank you for the opportunity.
Awesome. Well, I just, like I said, it's just sort of like a low pressure, no pressure way for people to get to know you, and so tell me a little bit, if you can. First of all, maybe why you got into law in the first place, what took you down that path, and why specifically wills and estates? What drew you to that part of the industry?
You're going to laugh because I never had a goal to become a lawyer. My parents did. They wanted me to be a lawyer. They said, you know what? You've got that sharp little tongue and a quick wit, and we think you'd make a good lawyer. And I'm like, oh, being a lawyer, it's not going to be very interesting. But what I found myself is I had finished my Bachelor of Commerce degree, and in Calgary at the time when I had finished, I won't say the year, you could probably do the math and figure it out, but the year in which I finished, we were in the middle of a recession, so there wasn't a lot of work out there, especially for a new graduate. So I said, you know what? My parents always said I would be a great lawyer, so you know what? Let's just take the Law Society admission test. Let's see where it takes us. Oh, I did okay. Yeah, okay. Well, what do people do when they do okay on the test? Well, they apply to law school. Oh, well, I got into some law schools. Well, I guess I'll go. And so then I became a lawyer. And I actually enjoyed it. It was a completely different world for me. But then when I came out on the other end, I got a job in the financial industry, because I'd worked for the financial industry during my undergrad. And I worked for a trust company and dealing with doing planning and estate planning for high net worth clients. And I took to it like a duck to water, and I've not looked back since. So kind of a long explanation, but basically to say, I never intended to get here, but here I am.
Sometimes in life, you work hard to figure out the path, and sometimes the path is kind of laid out for you. So that's fine. That's fine. I mentioned you have a broad experience. You mentioned the financial industry and that sort of thing. Now, you mentioned to me when we spoke in a previous conversation about how in your practice sometimes you have to deal with families, and maybe we should just actually, even before we even answer that question, maybe just tell us what does wills and estates mean? What exactly is that? And how does it relate to the life of a small business owner?
Wills and estates. So let's start on the will side. So I always think of the wills as the planning side. So this is when you're still able to make decisions and you want to have some sort of control over a time period where you will either be deceased or you might be mentally incapacitated. So we are looking to give you a level of control when you don't have control anymore. And so that's what a will does. And that's what an enduring power of attorney does. And that's what a personal directive does. And so you've worked hard in your business, you've accumulated some wealth. Do you just want it to be distributed as per the legislation in the province in which you reside? Or do you want to do some planning around it, make sure it's tax efficient, make sure it doesn't go to that brother that you haven't spoken to for 5 years, things like that, just to give you some direction as to the wealth that you've earned. Now, on the estate side, so that's the opposite. That's when a client has passed away. And now I'm dealing with an executor or a loved one that is surviving, and they don't know what to do with the estate of their loved one. And so I help them navigate what probate is. Is it necessary? What are the next steps? How do taxes come into play? So all of those mysterious questions that people, unless you're in that role already, don't know.
And you mentioned a word there that everyone hates to come across their lips, taxes.
Yeah.
But you also mentioned the word probate. I'm, at least somewhat familiar with the word, and certainly you are. Can you just
Mhm.
explain what that means for people that don't know what probate means?
So probate is basically when you have assets of the deceased that you need to deal with, but you have a third party institution or a third party like land titles, or maybe it's the bank, and they are looking for the owner of the account is where they get their authority and their directions from, but they can't speak to the owner because the owner is deceased. And so they look to the will to see who the executor is and who has authority. But you can imagine a bank would be hard pressed to deal with an executor when they don't know that that's the final will. So can you imagine releasing money to an executor and then you find out that wasn't the last will? That was
Wow.
the second to last will.
Mm.
And so then the bank has made a mistake and now they're liable for a lot of money that's now gone. And so probate is a way that those institutions can say, you know what, a court has blessed this will. And now, because there's a court order called a grant of probate, now the bank will listen to the executor because that will's been, I call it blessed, but that's just my colloquial term. So probate is not a dirty word. It actually might be a dirty word in other provinces, but the court to look at the paperwork and to give you that court order, it's actually very inexpensive in Alberta. It is only $525 at our maximum fee. But each province sets that fee differently. And so I always say, if you have $1 million house in Calgary and you pass away, and that house is part of your estate and part of your will, and someone's got to probate your will, our courts for that $1 million house will charge you $525. But in BC, their fees are 1.4%. So take a
Wow.
$1 million house in Vancouver and you have to probate it in BC. That's a
Yep.
$14,000 hit for probate. So yeah, probate really isn't a dirty word. It's just a means to make sure that third party institutions feel comfortable dealing with that will and dealing with that executor. And probate is not that lengthy of a process, really. It's only a beginning stage of settling an estate. So do not confuse it with probate, meaning the whole settlement of an estate from start to finish. Probate's only basically a first step before you even get into the administration of the estate.
Shoot.
That's probate. I don't know if I confused people or if it cleared it up. But in Alberta, I don't think of probate really as that dirty of a word. And taxes, yes, taxes are a consideration. That the biggest thing that people need to know is that when you pass away, the Income Tax Act says we're going to pretend that we sold all of your assets at fair market value. And what are the taxes that are going to result when there's that sale of assets at fair market value? And so there are some assets that don't attract any tax at all. So like your
Right.
principal residence, yeah, and things that have not grown in value, things like that. But for most Canadians, their RSPs will be a big hit because all of your RSPs are added into your income on that final year of death,
Yeah.
and any capital gains on rental properties or investments, shares, that kind of thing. You know, you've seen that, Cory. You probably
Yeah.
deal with that as well.
For sure. And yeah, thank you for clarifying that. There's obviously taxes are a big, as I mentioned, people hate the word, right? And so anything that people can do to avoid or minimize, legally minimize or avoid their taxes, that's something that we can, as someone in the financial services industry, I help people with that. And certainly in your planning in terms of what, how the estate is managed, I'm sure that you can affect that as well.
That's right. Maybe in some areas that if people don't do their proper planning, especially if they have a private company and they have private company shares, where sometimes what can happen is you can be taxed multiple times through your
Mm.
company, and then when you receive it as dividends. And so there are things that you can do in the estate, what we call post-mortem planning, which we usually get the help of a tax lawyer to guide us through some of those avenues. But so there's ways to try to minimize tax on a preemptive basis, but there are also ways to minimize tax on a reactive basis once someone's passed on as well.
And so what would be one of those ways that they could do that?
One of the biggest things is if you want to leave all of your assets to your spouse, you get to do so on a tax deferred basis. Now, you have to be very careful because typically in a nuclear family, so a family that has kids where the kids are the husband's kids and they are the same kids are the wife's kids, or whatever reiteration that we have, whether it be husband and wife that we have in this day and age. But so a deferral of tax happens when you give assets to your spouse, whether that's outright or whether it's through the will, whether it's outside the will, or whether it's through a spousal trust. But be careful, if you have a blended family, if you leave assets with your surviving spouse, and that spouse is not the mother or father of your children, we have to be very careful that we might not want to leave those assets there. So that's for more planning. Other ways that we can minimize tax is we can actually make charitable gifts through the will. And then you will be able to use some of those tax credits to offset some of the terminal taxes. Maybe deal with insurance. So insurance doesn't get rid of tax, but what it does is maybe taxes will erode some of the cash inside the estate. So maybe you want to use life insurance to inject some cash into the estate. And that's when someone like Cory can really help you figure out what's going to make sense for the estate. So that's sort of on the planning side when you can still do something about it in your will.
You mentioned different provinces. Every province sets their own fees for probate.
Mhm.
I have two questions around that. One is if someone has assets in more than one province, do they pay probate in both provinces or multiple provinces? That's question number one. And secondly, how are you licensed in multiple provinces or Canada-wide, or how do you personally sort of manage a situation like that for your client?
I'm only licensed to practice in Alberta, and so I would not be able to help anyone with probate in a jurisdiction outside of Alberta. But I have plenty of contacts outside of Alberta that can help as well. But in terms of your question about having multiple properties, so let's use a very simple example. Let's say you're a Calgary resident and you have your home here in Calgary, but you have a cabin on the lake in BC. And so what happens is if you where your immovable assets, so assets that are hard to move, such as land and buildings, they're going to be probated where the land is situated. Okay.
Okay.
So you can have, so in that situation, you're going to have to probate in Alberta, and then you're going to have to probate in BC. Now, you're not probating the same assets in both jurisdictions. You're probating all of your Alberta assets in the Alberta probate, but you're only dealing with your BC property in that BC probate. And where you are Domiciled is sort of a legal term. It's sometimes synonymously defined as residence, but it's a bigger concept than residence. But where you are domiciled is where your movable assets are going to be dealt with. So in our example, we're going to probate most of it in Calgary in Alberta because you're domiciled in Alberta. And then with respect to your BC property, we're going to probate in BC just for that property. So
Okay,
I don't know if that answers
excellent.
your question or just made it more confusing.
No, absolutely, absolutely. And so that's great to know. So anyone who's watching, I am licensed, just for the record, I am licensed in Alberta for insurance, as well as I have, as like yourself, I have other professionals and other expert partners in BC as well. So, for example, if just to sort of a little plug there for Alberta, I know we here in Alberta love Alberta, but if you're in BC and you have $1 million property, feel free to sell that, and move to Alberta.
Well, then they're
I
going to
love
get,
BC.
yeah, you've got BC land transfer tax as well. So they've got you coming and going. So
Every
we,
which
we,
way.
we joke. Yeah, it can be quite expensive in BC, of course, but you have to know your way around some of those costs.
For sure. And I love BC, full disclosure, and I have a brother there, and I love to visit there, and I plan to buy property there one day. So now, what if someone has property outside of Canada, or has, let's say, maybe a beneficiary lives outside of Canada or has moved outside of Canada? How does that play into your management of the final will?
Yeah. So if you have property outside of Canada, and there's basically two routes that you can take, right? So one is to have one will that covers both jurisdictions, though I think that's a little limiting because, especially if that jurisdiction is further away. And so sometimes we recommend that you actually have two different wills so that you have a will that restricts it to Canadian assets. And then you have a Canadian, and in particular, you'd want an in province executor. And then you would have a separate will for dealing with the assets in that other jurisdiction. And you might want to pick an executor that's also in that jurisdiction as well. And so you have to be careful to coordinate the wills because one of the first sentences in every will is I revoke all former wills. So whoever's doing that second will in that second jurisdiction, whether it be in that foreign place or whether it be in Canada, you have to be careful to say that this will is only for this particular jurisdiction, and it does not revoke this other will that I've made that is meant to work at the same time. So you have to be very careful around that. Now, in terms of beneficiaries being in different jurisdictions, I can't say countries outside of US, but because we're neighbors to the US, sometimes we have to be very careful what we give our beneficiaries who are US residents. So that's probably beyond the scope of today's discussion, but it would be hard pressed to find a lawyer who knows every country and
Of
what it
course.
means to have a beneficiary in that particular country. But because we're so close to the US, sometimes we know that there are some red flags or some traps that you can fall into when you don't get proper planning with US beneficiaries.
For sure. And I'm glad you brought that up. I don't think anyone expects, that one lawyer would be an expert in every jurisdiction around the world. But I did want to touch on that because I remember in our previous conversation that we'd had, that had come up and we discussed that. But really, the point is, some of these matters are very complicated. There's a reason why someone like yourself is an expert in this in the province of Alberta and can adequately guide someone in preparing their final will and estate planning, right? So, so I want to make sure we make a point of that. So now, having said that, I guess what I'm getting at is, so you don't have to have extra provincial or extra out of country assets for a will to be complicated. How complicated does a will need to be for someone like yourself to get involved in helping with it? And maybe could you give an example of something that's maybe complicated within the province that someone
Yeah,
particularly wants to get your help with and not just do a will off the internet or something?
that's a great question. Wills are a really, really funny area because people who don't practice in it just think, you know what, I have a very simple situation. I can't tell you how many clients have come to me and say, you know what, I have a very simple situation. And sometimes It is, they say, you know what, I only have these few assets. And it's not the assets that necessarily create the complexity. So what for me creates some complexity is if you have a disabled beneficiary. So you've got a beneficiary that you can't hand their inheritance to them because they're unable to manage money, or you might even bump them off of government benefits. And so you have to structure your will appropriately to set up a trust sometimes in the will so that that money can be managed for that beneficiary over their lifetime. So it might be that you only have that one GIC and a mutual fund account and just a house, so your assets aren't complicated. But because you have a special needs beneficiary, that brings in the complication to the will. We also have situations where we have beneficiaries that live in other jurisdictions, so that creates the complexity. Another reason for complexity is the blended families, because I see all the time people coming in and they say, you know what, I'm going to leave everything to my spouse. And then when my spouse passes, we're going to split it with her kids and my kids. And what I call that is hope and prayer planning, because what you're doing is if you're the first to die, you're leaving all of the ownership of those assets to that surviving spouse. Remember, you are gifting them all those assets. They own those assets after you die. And because they own it, they can do whatever they want with, which means they can change their will after you die. And so people think of the will when they come into the lawyer's office and they prepare two wills. They think the will is a contract that you're tied to this. No, you, by dying first and fulfilling your obligation to give everything to your spouse has no obligation to give it to your kids. They can change the will and redirect those assets to whoever they want. And so blended families create different things that we have to do to make sure that your kids are included or your spouse is included. We've got it going the other way where people want to give it to their kids and not to their spouse because they've kept their finances separate. And so we have to navigate the tax laws because you're not giving anything to your spouse. You don't get that tax deferral.
Right.
Because you're not giving it to your spouse, who under the law is considered a dependent, you may have legislation that says, hey, if your spouse doesn't have enough support, they may have a claim against your estate.
Right.
So sometimes there's complexity where you don't even anticipate there's complexity because you didn't understand how the law applied to your situation. And the last thing is division of matrimonial property has now changed to include division of property when you're a common law couple and you break up. And those same rights go to a surviving common law partner or a surviving spouse where they may have a marital claim against some of those assets or a common law claim against those assets. So best to share all the information with your lawyer, and they can wade through all the laws and explain to you which of these laws apply to you, which ones don't, and then how do we navigate around those laws, or how do we work with those laws?
Great, thank you. That's very helpful. And one scenario, you didn't mention this, but some of our viewers will think of this, and so I'll ask it or bring it up is, so you give all your assets, you gift them to your spouse, thinking your spouse in a blended family situation, thinking your spouse is going to split them with your children and her children, or your children and his children, as the case may be. Well, then that spouse, after you pass away, remarries. And that new spouse maybe has children, and it can get quite complicated.
Yes. So, I actually had a client that was on his 5th marriage. I think that was the one that stuck. But can you imagine, like, I think he's had kids all along the way with all the different relationships as well. So planning in that type of situation can be quite complicated, right? So yes, people think their wills are uncomplicated. And the other thing that people do is they say, you know what? The will covers all of my assets. I know what I own. I know who I want to give it to. Therefore, why can't I just write it down? And why do I have to overcomplicate it with getting a lawyer? Well, here's the thing. There are beneficiary designations on things and potential joint ownership that actually remove those assets from your will. So if you have, for instance, an RSP and you've got a beneficiary already on it, that is not part of your will anymore. It will go outside of your will directly to whoever that beneficiary is. And so I've seen people who forget about those beneficiary designations. They create their own will, they do a division of their assets. And because they forgot that beneficiary designation overrides your will, the
Mhm.
distribution was not what you thought it was.
Right.
Right.
For sure. Yeah, yeah. As you mentioned, it can become quite complicated. So I would strongly recommend whether the person's in Alberta or outside of Alberta, or whether they call you or another competent lawyer, they should call a lawyer and at least do an initial consult,
Mhm.
and just say, here's basically where I'm at and what I think, how simple I think my situation is, and someone like yourself can say, well, do you have this? Do you have that? What about this? What about that? And probe to see if it really is that simple. But even if it is a really simple will, I mean, that much easier for you to create a legal framework around their wishes, right? So that's not, it doesn't have to be complicated for them to call you.
Exactly. And I think the will is sort of like the star of the show. People are, it's sort of if you could call wills glamorous. Wills seem to get the most hype and the most attention. But I almost feel like the enduring power of attorney and the personal directive needs some attention as well. And so the enduring power of attorney is a document that you create now that says, hey, in later in life, if I should lose mental capacity, who do I trust and who can I name to make financial decisions for me? And so that can be a spouse, that can be a friend, it can be a sibling, it can be your adult children. And so you do want to put that in place so that you have someone making decisions for you if you're unable to do that yourself. And then the personal directive is yet another document that allows you to pick a trusted family member or a friend to make healthcare and personal decisions for you. So anything to do with not making financial decisions. And those people will be helping you make medical decisions. They'll be deciding whether or not you can still live in your own home, or are you a danger living in your own home? Can you still drive? Or are you always backing over the neighbor's cat? Like maybe we should be taking away your driver's license or having your eyes tested. So those things are in the realm of the personal directive, where you pick a family member or a friend that you trust who will make those decisions for you when you're not capable of doing that yourself anymore.
Right.
So
That's
those are
sorry,
important.
go ahead. Yeah, for sure. And you mentioned that, a trusted person and a power of attorney, enduring power of attorney. There's, as you know, there's a phrase in the financial services industry called a trusted contact person. And I just want to touch on that briefly. If someone's looking some of these terms up and things, they may be confused by that. So a trusted contact person is someone that we, and I'll ask you in a minute if this is incorporated anywhere in the documents that you normally create. But in our processes, we ask clients to name a trusted contact person. That person is not a power of attorney. They don't have access to the dollars or to even the amounts in the client's accounts, but it is someone that we can call if if clients exhibit behaviors that are out of character. For example, if someone is unbeknownst to themselves or maybe their family, they develop some dementia or something like that, and they're starting to show symptoms of that,
Mhm.
where their behavior is unusual or odd, or maybe affecting the security of their investments, i.e., their retirement income and that sort of thing, their assets, their estate. We can contact that other person and say, hey, can you just check on insert client name here? Something doesn't seem quite right. Can you just check on them? And that gives them a backstop against things like fraud, which is more and more prevalent nowadays in as people's assets and estates grow pre-death. There's a lot more cases of fraud going on. So
Yeah.
is that something that is a part of or incorporated into your documents, or is that
Yes,
something more? Yeah.
it definitely can be. And it reminds me of a story of a client I just talked to actually last week. And the elderly mom still has mental capacity, but she's getting more vulnerable. And what had actually happened was that she fell prey to a scam where it's the grandson, a fictitious grandson, which the elderly client thought was her actual grandson, phoning saying that he was in trouble and he needed money. And so the elderly client had gone to the bank, and it was actually the bank that said, you know what, this is unlike you to pull that kind of money out. You know what, are you okay? Like, can I have you phone your daughter and just check to make sure that this is okay? And that's how the fraud was actually stopped. So that trusted contact is so important. And I'm so glad that you guys do that, because there's so much vulnerability in seniors. They might not have completely lost mental capacity, but there's that gray area where they're feeling vulnerable and they can fall prey to some of those scams. And so you can also include that in the document. The only challenge with those documents is some of those documents only take effect when you've completely lost mental capacity. And so if you have a trusted individual in that document, then that document is sort of inert and not in play yet.
Hmm.
And so you have to have had the client who lost capacity before the document comes into play, before that trusted individual is mentioned in that document. It's probably better through the banks and through financial institutions like yourself to set up those trusted individuals, because your document might not come into play just yet. But you can do a power of attorney that is in play now, even though you haven't lost capacity. But that might get us a little confused and complicated, and we can dive into that further if we want to in future episode.
Sure, for sure. And speaking of which, definitely we'll have you back and go into some other and related topics in the future. And thank you again. We're not done here, but thank you again while I'm thinking of it, for joining and participating tonight.
Always.
Now and you mentioned, it's for vulnerable. This trusted contact person that I mentioned is for vulnerable persons.
Mhm.
No matter their age, to be fair. And I say that because people of all ages can have unexpected life events. Whether it's as we say in Calgary, driving down the Deerfoot, accidents every day or nearly every day, injury, critical illness, things can happen out of nowhere. And so that's why it's important to have whether the person is a teenager with investments or thinking about their future planning needs, or whether they are, a senior citizen advanced in age. Yeah, it's for everyone. So don't think it's just for, quote unquote old people, right?
Yeah, so I'm glad you guys do that. That's so, it's so heartening to hear that the industry is looking out for their clients.
Yeah, and I'm really glad too. I when I was years and years and years ago, I did some volunteer work when I lived in the States around vulnerable seniors and vulnerable persons and financial abuse, elder abuse, that kind of thing. So it's something that's close to my heart. So I really, really am thankful that we do that as well. Now, I thought of a scenario earlier as we were chatting, and I want to mention it now because it's pertinent to our typical viewers of the show here. What about, so let's say someone owns a business and they've got business partners, which may or may not be their spouse or common law equivalent. It's probably not important that they really plan for their, final wishes, right? It's probably just, they can just put it on a napkin and not worry about it anymore. Would that be a fair statement?
See, and I love that type of thinking, because what you end up doing is litigation lawyers will be fed very well, and their kids will be put through school, trying to clear out some of those problems that arise. So I don't do any litigation, so there's no incentive for me to make sure that there's as much of a mess left behind as possible. In fact, I do the opposite, because I don't do litigation. I try to prevent some of that from happening. So that makes so much sense. Like, even the simplest of examples, when let's say you have two business partners, let's say that they're two engineers, and they go into business together, and they are the ones that provide the technical expertise as well as the ownership and running of the company. And so what happens if you don't have an agreement in place between the two shareholders? So one engineer passes away, everything, let's say his will gives everything to his or her wife or husband, and then that spouse is now a shareholder of your company. So now you have someone who's not technical in the business, left with the remaining engineer.
Hmm.
And is that something that you had wanted for your business? So it's so important. So this is outside the area of wills and estates, and it's probably more in the area of corporate law. And so
Right.
we have corporate lawyers, which I know you have worked with some really amazing corporate lawyers, and
Yes.
they will help put together shareholders agreements for co-owners of business who don't want to become business owners with the spouse of the deceased business partner. So yes, there's lots of planning that can be done to make sure that everything goes the way that you intend.
Yeah, and I appreciate you mentioning that. Yeah, I said it obviously in jest, but yeah, so it's kind of all intertwined in the sense that you plan, you create business plans, you create marketing plans, you create succession plans, and or at least you should. How you deal with your business assets in relation to your estate, and in relation to, and some of that is like dealt with, like you say, these shareholder agreements and things like that.
Mm-hmm.
But it certainly needs to be something that is on the table when they're talking with you, and you do the probe. You'd ask those kind of questions. What kind of assets do you have? Do you own a
Yeah.
business? I know you'd ask all those questions, right? But other lawyers, junior lawyers, they may or may not. Someone fresh out of law school may, maybe
Yes.
forget to ask a question or whatever. But for the business owner to know, lay everything out there, right? Your lawyer is a trusted professional. Lay everything out there that you have and say, okay, hey, if this can't be dealt with adequately in my estate or my will, can you recommend someone to help me make sure it's looked after? And some of
Exactly.
those things are done, yeah, like you said, some of those things are done through shareholder agreements. Some of them are done through insurance and things
Mm-hmm.
like that. Insurance is a way that, as you know, that if one partner dies, the business can have insurance on them such that now their shares are bought out from the surviving spouse or family, right? And then the business can carry on, et cetera, et cetera. So lots of
That's
ways.
yeah, perfect way to go. So then the spouse gets the money and the value of those shares without actually being a shareholder. And so maybe that's a win-win. And that's where, Cory, you can come in and help with all of that as well on the insurance side. So I do like working with financial advisors because they provide a lot of value and expertise in dealing with some of those situations that my clients find themselves in.
And I appreciate you saying that, Angela. Just speaking of value, one reason why I, love being in the financial services field is because of the value that a financial professional adds to a person's, portfolio or to their assets. It's been proven, and I didn't come prepared to say this, but or so I don't have a slide to demonstrate it, but maybe in a future episode I will. But it's been demonstrated in Canada. There's been studies that show that over time, the value of a person's, typical or average person's portfolio does grow larger with the advice of a professional versus doing it on their own. Not, obviously, not every case, and et cetera, et cetera. I'll put
Mhm.
the proper disclaimers on this for that. But yeah, but absolutely, value is something that professionals add to business owners and to protecting
Yeah.
and growing your estate, right?
I
So
agree.
um,
We we can't be experts in everything. I mean, there, as you know, there's so much for you to know. There's so much for me now. I'm even 25 years in, I'm still learning something every day. And so if your experts are still learning, how do you keep on top of different subject matters? So you have to rely on the people that are studying it, the people who are in it, the people who deal with it day to day. So yeah, leverage that help for sure.
and one last thing I'll say about this, and then I'll stop talking about my industry because I'm really not here to do that. But I feel it's appropriate to clarify it. Like as you said, like there's tens of thousands of mutual funds out there. So one person, the smartest person in the world, can't possibly know all of them in depth. So, and I can't either, right? Because I'm not the smartest person in the world either. But just the point being that there's a reason why different professionals like yourself and like myself have studied the things that we do and bring that to bear to serve people. So anyway, enough about
I
me.
do I do joke. I'm like, I think I'm lucky to even know how to spell mutual fund. Of course. So I'm just joking, of course.
Yeah.
But so I try to bring some levity, where appropriate with my clients, because sometimes will planning can be quite a heavy subject. And of course, there's situations where they are quite heavy, but where we can, make the planning a little bit more lighter, and if we can get them through it without feeling that it's all doom and gloom, sometimes it's the way to go.
For sure. We're nearing towards the end of the time that we have together, and I want to respect your time and our viewers' time. So we've discussed a number of different things. Is there something that you think is critical that people should know that I have not asked you, or some part of your job that you wish people knew more or understood better to help them make a good choice in terms of first of all committing to do their will and estate planning, but also who to choose when they do that?
Yeah, so I get on my soapbox a little bit, and so this is kind of a dangerous question that you asked me, Cory. So I because I have some experience in the early part of my career reviewing wills of other lawyers, I've come to the opinion that there's a lot of lawyers who prepare what I call dictation wills. Now, dictation will isn't a true term; it's something I made up. And a dictation will is when a client comes into a lawyer's office and the lawyer does not find out about the ownership of the assets or whether there's any beneficiary designation. So, in other words, they don't know what's inside the client's estate when they pass, because a will only distributes assets that form part of the estate. And some of those things that you do, like designating beneficiaries or making things joint, actually remove assets from your will and your estate. And so when you're having a dictation will crafted, it just means your lawyer's just taking down your instructions like I call it a glorified drafting monkey.
Mm.
Hey, client, just tell me what you want to put in the will, and I will just regurgitate it on paper. And here we're going to make sure that that's put into a will. But you have to go to a planning professional that you can see them asking about the ownership of your assets and finding out which assets are part of your estate, because nothing is worse than creating a will that directs the distribution of estate assets, but there were no assets through the estate. So best example is you have husband and wife, longtime married couple. They've been married 50 years, and they do the typical thing where all of their assets are held jointly. And for the things that can't be held jointly, like RSPs, they name each other as beneficiary, and on tax-free savings accounts, they name each other as successor holders or beneficiaries or what have you. And life insurance, they've named each other. And so on the passing of the first spouse, all of the assets of the first deceased spouse pass outside of the estate. So if you think of the estate as a box, that box is empty. And so that will of the deceased person is directing the division of any assets in that box. Well, there's no assets in that box. And so your
Mm.
will is not distributing anything. So what happens is all of those assets bypass the box because there's another owner, it's still alive, or a beneficiary alive who takes those assets from outside of the will. And so if you put in your will that there's a gift of $10,000 to another individual, that will is pure fiction. That 10,000, there's no money in the estate box to allow that gift to happen. And so you can only hope and pray that the spouse who ends up with all of those assets will take 10,000 from their own newly acquired assets to give it to that beneficiary. So that's what I call hope and prayer planning. It is
Right.
not a proper will. And so that's, if I can leave people who are watching or listening to this with, it's so important that you find the right professional that asks the right questions, and not all professionals are created equal. So if they can't tell you what's inside your estate when if you were to pass away, maybe that individual, you might want to look at having someone who's a little bit more specialized.
For sure, and I appreciate you saying that, and that's why I love that you have a diverse background of experience. Like I mentioned before, from banking industry, government, and private practice, because you get a whole wealth of different angles and perspectives on things that you've seen, like you mentioned, over the years. So someone I think will be well served by giving you a call. So we'll share your contact information at the end of this for sure. Now, I do want to ask if you're willing to share, or if you're able to share. Someone might think, well, okay, this all sounds great. I think my situation is simple, but inflation is going on right now. Costs are going up everywhere. I'm not sure if I have a lot of money to invest in making sure all this is, because I don't think I'm going to go anywhere for a long time. What's the hurry? It's not going to happen to me, sort of thing.
Mhm.
What sort of price range, or how does that, if you're comfortable sharing, what's the range on what it would cost someone to have some of these things looked at?
Yeah, so like I said, we talked about complexity. So if you have disabled beneficiaries, if you yourself are a US citizen, that might create some complexity. If you have a blended family, that creates complexity. If you have complicated wishes that have formulas and combinations and permutations all in the will, that adds to the cost of the will. We typically, for let's use a husband and wife as an example, we normally do 6 documents. So we're going to do a will for each of them. We're going to do an enduring power of attorney for each of them, and we're going to do a personal directive for each of them. So our current pricing is about just under $1,600 for all 6 of those documents. You get
Wow.
an education. You get to see what's inside your estate. I draw a picture for you. And we would look at the flow of the assets. We make sure that how your assets are owned fit with the goals of your estate. So everything is looked at. And then we double check beneficiary designations and all of those things to make sure they are what they should be. And then if we do a good job on the will, the documents have all backup beneficiaries and backup executors and backup guardians. So the idea is if we can create a very complete document, you don't ever have to change that document again. So it's if you get one set of wills, it's a great investment, because if you don't ever change it again, boy, that was a great deal. You never have to update that will again. But of course, people do change their mind. They want to update things, but there's no requirement to necessarily change a will unless you want to. And so that's a great investment, because once you get a complete document in place, that could be your will.
And having said that, if someone has a will that they maybe made last year or years ago, and they're like, I'm not sure. I didn't hear the kind of questions from that lawyer that, Angela's presenting here or Cory's bringing up. Maybe I should have it reviewed. Obviously, they can contact you to have their current will and these documents reviewed as well,
Yeah,
for
so I do
sure.
that on a complimentary basis, just because I know there's so many wills done out there that aren't necessarily what the client intended. I will review wills for clients for free, so I'm
Wow.
happy to do that.
Wow, that's generous. Thank you very much for that. There was another question that popped in my head, but it popped out again. So we maybe save it for save it for the next episode and when we get together again. But
Fair enough.
is there anything else? Again, I'm not afraid to ask dangerous questions. Is there
Yeah.
anything else that people really should know, or have we basically covered the key
Yes,
things?
please don't make written changes on your original will. People think, oh, well, I want to make that change. I don't want to go back to the lawyer and pay a fee to update that. But what you don't realize is that someone has to establish that you have mental capacity before a change is valid. So if you're by yourself making changes, I always joke you could be on an acid trip and you're not understanding what it is you're doing. You're just thinking that's a good idea to pull out your will and start making changes. And so someone has to verify that you have mental capacity, and those changes have to be made in front of 2 witnesses. And so the witnesses have to see you sign. You have to see the witnesses sign. The witnesses have to see each other sign. And the
Mm,
witnesses cannot be beneficiaries. And so
mm.
people go all sorts of wrong when they try to make changes on their own and don't realize the effect of what they're doing. So that's another dangerous point it's like when you make a mistake on your check. When you write, do people write checks anymore? But when you write a check and you make a mistake and you fix the figures and then you initial it, you can't do that on a will. There are certain requirements that need to be met in order for a will to be valid. So please don't mess with your will without getting proper advice.
Interesting. Yeah, that's very, very good to note. And speaking of which, that does bring up another question in my mind. Some of the things that might, I don't say automatically, but might certainly consider someone to almost pretty much automatically look at changing their will.
Mhm.
One might be a divorce, for example. But what are some of the? Are there any other things like that may automatically trigger you need to have your will looked at or adjusted?
Uh, I think if there's a divorce, for sure. Like, what if your spouse is on the will? Maybe you don't want your spouse to get all of your assets. So, a divorce is a good example. You should update your will then. If you get married, maybe you want to share with your spouse. when you have children, when your children are grown, because what I find is a lot of people prepare wills when their children are infants, but now their grown children have introduced their own partners, and that creates a different dynamic in the family, and that creates a different way of thinking and looking at the wills. And sometimes clients will change their will quite drastically once their kids are grown. Maybe your beneficiaries have moved away, and so like for me, my son has moved to California. I can't make him my executor anymore. It creates some complexities if he is my executor. So what I had planned to have him as my executor, now I may want to rethink that. And so those are some simple examples of when you should review and potentially update your will. Or if you're just not happy with the distribution, you've had a falling out with so-and-so, they have to come out of the will. Or you've had a birth of a grandchild, and maybe your adult children are fine, they're independent, and maybe you want to provide more for your grandchildren because your kids don't need it. So those are the sort of common things that I start to see, right?
Excellent. That's good. Thank you very much.
You're welcome.
Yeah. So obviously there's lots of different scenarios that can affect a person's need to update their will and related documents. I was going to ask you another question, but I think I'm going to leave it for part two, or
Oh, you leave me hanging.
I'll leave you hanging. I'll leave our guests hanging a little bit there. Open a story loop, as they say, and leave it hanging there. So during the commercial break. But yeah, no, and as I said, I want to respect your time and the time of our guests watching. So I think unless there's something absolutely pressing on your mind, if there is, please share. Otherwise, I think what we'll do is we'll close it off here. I'll just remind everybody, this way here. Here's the QR code to book a free, I call it a discovery call with me. I think the schedule is 15 or 30 minutes, but I'm not tied to that. I want people to have a chance to just see if we're a good fit to work together. I have, what's the official word I need to use? Colleagues. I'll use the word colleagues. Some colleagues that might be a better fit for you than me, and that's fine. I don't take that personally. If we're not a good fit to work together, I don't want to burden you with obligation to me. Let's see if we're a good fit to work together. If not, I'll recommend you someone else that I think will be. And as well, if you have other needs beyond the matter of estates, wills, and estates, I have other expert partners such as Angela that are experts in other areas of law, of accounting, of different business and non-business specific skills that I can refer you to help you further grow and protect your business and your personal portfolio. And as I mentioned before, I'm going to put Angela's contact information. I'm just going to share the screen here. I don't need to hog the whole screen, but I'll put your contact information up for people to to get a hold of you, and so they can do that. And yeah, it's been a great approximately an hour. Thank you again so much for your time, Angela. And I know you're a busy person and busy professional, and you've got lots going on. So I appreciate you taking the time out to help us tonight.
Well, thank you for giving me the opportunity to chat. As you know, I'm very passionate about this, my wills and dealing with estates. I love my job and helping clients. And so being able to share that with your viewers is wonderful. And I don't know why anyone wouldn't want to work with you, Cory. So
I appreciate that.
Yeah, thank you again.
Yeah, but I'll be the first to admit I'm not everyone's cup of tea or everyone's bottle of bourbon. So
yeah, and I of course okay. I won't be either, but, but I like to joke about it. So anyway, yeah, thank you sure. again for having me on.
I appreciate that. Thank you so much. And for our viewers out there, if you're watching regularly or listening regularly, we'll be on iTunes and that sort of thing. So you'll be able to find the audio everywhere, video on YouTube, that sort of thing. Otherwise, we do have another weekly scheduled open office hours set up for next Tuesday at 7 p.m. Mountain Time. So you can go to the link on Eventbrite, and it is free to sign up. You do have to just register there to get the link, and we look forward to seeing you there in the future. Thank you, everyone. Bye for now.